Yes, Ms. Heather.
My Lord, if I could deal briefly with a few points arising from the Section 8 notice.
Yes.
Appeal. I think there are 5 against me, if I'm not quite right. The first point is about the whether or not the Section 8 notice should be signed or not.
Whether
the Section 8 notice must be signed or not. It was suggested that effectively handing it over might be sufficient, even if it's unsigned, and taken to the certificate of service by which it was shown that it was hand delivered. In response to that, I say that it's not good enough just for a Section 8 notice to contain the information which is required and to give the tenant the appropriate warning. And it's my Henry II point that I make in the skeleton. You can't have an officious bystander who becomes aware that the landlord wants to give a Section 8 notice and then draws it up, runs off and gives it to the tenant. In those circumstances, it hasn't come from the landlord and it's not signed, and that would not be good enough.
Well, it wouldn't be authorised.
Well, it wouldn't be authorised, no. So I wanted to make that point.
Not sure it matters, but that wouldn't necessarily be a good enough reason for saying that an unsigned notice wasn't good enough if the rector had turned up on the tenant's doorstep and handed it over.
Well, my lord, I would say that because of the nature of a Section 8 notice, as I said before, the shorter German, it's the landlord vindicating his own property rights, and secondly, he is seeking possession of the tenant's home, and those are circumstances where formality is required, I would say, and that goes as far as notice being signed. There is no authority directly in point. There you've got Stidolf, which I referred to this morning, where it was assumed, and then you've got Devlin under the parallel provision under the 1985 Act. So notice seeking possession of a secure tenancy. That was only a permission to appeal application, though. So again, it's not in no sense binding. My second point is the general law of agency and its role in all of this. I say, and I may have touched on this earlier, it has been overtaken by Section 44. That is the purpose of Section 44, and prior to that, Section 36A.
Well, what do you do with the check example?
Well, there are obviously, I would submit, some categories of document for which it is not appropriate to speak of execution. And a check probably falls within that. Some forms of correspondence also wouldn't form.
So document means what?
Well, I think...
Or does it not turn on document, it turns on execution, does it?
It has to be both of them.
Right.
And for the purposes of today, I repeat what I said this morning, that a notice has to be a document.
Yeah.
There doesn't seem to be any
You started this submission by saying the general law of agency has been overtaken by Section 44.
Yes.
That's a very broad submission.
Yes. So far as you've got the various common law cases, which both sides have referred to in their skeletons, about things being done on behalf of companies, signatures, contracts, and various other kinds of documents. And those cases show the subtleties which are sometimes involved, whether the execution was by the company or on behalf of the company, so on and so forth. But the parliamentary intervention in 1989, in my submission, really does focus the mind on most categories of execution of documents. It was, and in Section 44 remains, a very broad provision dealing with companies and how they bring about documents. I would suggest that, so far as the definition of document is concerned, it's very broad and plainly includes a notice. And as bold a submission as it may be, Section 44 really does do what it is meant to do, what it says on the tin.
So, but you accept, I think, or perhaps you don't accept, that in the check example, there's no need for the signature on the check to comply, signatures plural on the check to comply with Section 44. The check is a document in the ordinary meaning of the word. So you would say the broad width of Section 44 is to some extent cut down by the notion of execution. Is that how you put it?
I would say that it is perhaps the wrong side of the line to speak of executing a check.
Does that mean there's a fourth category?
No, it doesn't.
Why not?
Because effectively the acts don't envisage there being one, as Lord Justice Lloyd said clearly in Fearn. I think if I can go back to help me, just to remind myself exactly what he did. Tab 21.
Well, if we look at paragraph 27, which is where the categories come from.
Yes.
Lord Justice Lloyd starts by saying there'd be 4 different categories of document made, to use a general word, by a company. Contracts, category 1. Deeds, category 2. Other documents executed by a company, that's 3. And yet other documents made by a company but not executed, to which none of these sections will apply. I think in answer to Lord Justice Newey, you accept that a cheque, which is on the face of it a document, would not have to be, quote, executed, unquote, in accordance with Section 44, but it would be made, to use Lord Justice Lloyd's word, by a company. So that means there is a 4th category, doesn't it?
Well, yes. The passage which I had in mind was later. It was paragraph 31.
Well, can we just bottom out paragraph 27? I think the implication of your submission is that there is a 4th category of document made by a company which is not governed by any of the sections to which Lord Justice Lloyd refers, but which is governed by the general law of agency. Is that right?
What I would say about that is that the answer would probably lie within the constitution of the company and or the provisions by which directors and or other employees were authorised to deal with checks. And it would also be subject of arrangements between the company and its bank. So,
is that a 4th category or not?
It's a bit of a grey area, I would say. What I wanted to take you to was paragraph 31 of Lord Justice Lloyd's judgment. speaks of a document which is required for some formal legal purpose.
That's true of a cheque. That's the authority to the bank to debit the account.
Yes, but not necessarily the... Well, if that is the definition of cheque, then I would say that a cheque is a document which is required to be executed. If it's put like that as a formal legal authority of the bank, then yes, and the grey area resolves itself.
There's something mysterious about the word formal legal purpose. I mean, if you excluded the word formal, you would undoubtedly capture a cheque because it is required for a legal purpose.
Yes.
He seems to mean something by formal, which,
Yes. Well,
in which case I'm not sure quite how it sits so easily with paragraph 27.
What about the company's tax return? That's required for a formal legal purpose. Does that have to be executed in accordance with section 44?
I don't know what the execution provisions are at the end of a company tax return and what is.
Well, that doesn't matter on your argument. Section 44 trumps anything else.
Well, again, as I say, I do not know whether it is actually the case that a company's tax return has provision for execution in accordance with section 44. I've never seen one. It might be the case that it does. If it doesn't, yes, it is potentially a document which is required for some formal legal purpose. But again, there are practical ways around this in terms of powers of attorney, authorised agents under section 74, subsection 2, and subsection 6. And
Is one answer to this that a cheque is not a document that is required to be made by a company? It's sufficient that it's a document that is executed, made, signed, use whatever word you will, by an agent that the bank recognises by reason of the mandate as having the authority to act on behalf of the company. And that's the explanation for the cheque, is you don't need to fit it within these categories at all, because these categories are just talking about contracts which are required to be made by, the critical word is by a company. And so, you see, I think your submission was that section 44, section 36A has cut across agency. And what I'm suggesting is that perhaps this is limited simply to documents required to be made by, rather than using the mechanisms of agency, of which the cheque would be an example.
if I may respectfully say, your answer to the question that was put by Lord Justice Newey was better than mine in relation to the cheque.
But it does mean that your general and very wide proposition that section 44 has cut down the facility of a company to use principles of agency can't be correct as broadly as you put it.
Well, it certainly has cut it down because it defines how companies bring into existence documents.
Well, it doesn't cut down agency, it's just dealing with a different situation, namely a situation where, for some reason, a document executed by an agent isn't good enough.
Yes, but I would say that's the Hilmy point, the very narrow point in Hilmy. And I say that section 44 does go much wider than that. And as I said before the adjournment, the practical ways around the apparent burden which section 44 then imposes are found elsewhere, for example, section 74 of the Law of Property Act. So it is possible for a company to authorise agents to execute documents. And they can do that either by board resolution, section 74.2, and they can also, section 74.6, have a bespoke form of execution for a company.
Paragraph 32 of Lord Justice Lloyd's judgment. Quite right. In the light of section 74.2. Or was he focusing entirely on the company itself signing?
Yes, that seems to be from the very narrow perspective of the section 13 notice and section 99 of the of that act.
So when he says it had to resolve, unpacking that, what he means is section 99A meant that it had to.
Yes.
Is that that's how he...
99.5a.
99.5a. That's what he means by it had to. If he meant I have previously held that section 99.5a, as distinct from 5b, means that it had to.
The company had to.
That the company had itself to sign the document.
Yes.
That's his point.
Yes.
Right. That's point 2, is it?
That was the second. Yes.
Yep.
The third point is this. It was submitted to you by Mr. Bates that it's odd that you can create an interest in land by section 43 of a short tenancy because section 43 permits only one authorised signatory, but that you would need more to bring it to an end. And well, I say in response to that, there are possibly good policy reasons why it should indeed be that way around. It's one thing to create a home for somebody, which it is possibly a good thing in society if that is rendered comparatively straightforward, to create an assured short-hold tenancy, but to resolve to bring that to an end, to vindicate your property rights and to seek possession of somebody's home is an entirely appropriate occasion for a degree of formality, I would say, in response to that. Again, related to the complications of a Section 8 notice, such as it's being found invalid.
Is this the fourth point?
Fourth point, my lord, yes. It's always open to a landlord to serve a fresh notice.
Always open?
To a landlord to serve a fresh notice. And that I hope is an obvious point.
Yes.
It's not a once and for all opportunity which is lost if a Section 8 notice is dud, and the county courts are full of arguments which are successful about Section 8 notices and Section 21 notices being effective for various.
That doesn't apply to the certificate, though, does it? You can't serve a late certificate.
Yeah, yes, I think you can. It's
Thought you
yes,
one stage could and now you can't, but perhaps I'm wrong about that. Because the word landlord's given a grace period by the Deregulation Act.
Yeah, they can't serve a Section 21 notice until they've effectively put matters right. I think it's a Section 215. Yeah.
Oh, I see. So you can serve a late certificate.
Yes, it's not in the bundle, but pretty sure I recall that's the case. I think my learned junior has or may have a copy of Section 215. May we come back to that?
Yeah.
And the last point was this. It was just to go a little bit further in relation to the authority of Miss Miles' point. Having taken instructions over the short adjournment, My understanding is that it wasn't until the handing down of the judgment that the issue of who had given the Section 8 notice reared its head. So it was after the appeal had been heard.
So it was after the hand down of Justice Saini's judgment or Judge Williams' judgment?
It was after the hearing. The hearing was on the 8th. The statement is the 10th.
Sorry, it was after the hearing had been concluded, but before the handing down of the judgment.
In the hearing in front of Mr. Justice Saini?
Yes, yes. So the hearing had concluded on the 8th of December, and the witness statement was 2 days after that, in response to things which had arisen during the course of the argument. On the authority point, you were taking the pleadings by Mr. Bates, and I wanted just to clear up any uncertainty that may exist, and I do say may exist, in relation to the pleadings. So if I could take you to the re-amended defence counterclaim in relation to the certificate point.
Sorry, just hold on a minute. Re-amended defence.
Yes. So this is in the call bundle, tab 17.
Yes.
And it's paragraph 16b, page 178.
16B. Yes.
So the averment made is that as a director, Elizabeth Brown was an authorised signatory. It's contended that the notice remains defective in that there is no signature from another authorised signatory on the Appendix 8 documentation, or there is no evidence of a witness attesting Elizabeth Brown's signature. It is averred the claimant has not executed the confirmation document required under Article 21G7 in accordance with the requirements of Section 44.
Yeah.
So I just wanted to make clear that it's understood that the averment which is made there is she was not authorised, that she was an authorised signatory for the purposes of the Companies Act, Section 44. It's not an acceptance that she was a generally authorised signatory of the kind, perhaps, envisaged by her witness statement. Sorry. I don't know quite what the point that was being made in relation to that, and whether it was suggesting she was authorised in some other way, but if one reads the whole paragraph, I suggest it is plain that it was an authorised signatory within the meaning of Section 44.
I think the only point that was being made was that the challenge was to the form rather than to the authority.
Yes. Right. I'll come now to the certificate of compliance point. I think I can be fairly brief on this. It might help to turn it up if I could invite you to do that supplementary bundle. And tab 4. So my submission is the same three questions that I propose in relation to the Section 8 notice apply here. The first of which is who on the proper construction of the certificate has purported to execute it. And I say the answer to that is it purports to be executed by the landlord. We see that because of the words, we being the landlord certify that. 1, 2, then landlord's name and signature. There isn't a suggestion that it is anyone other than the landlord who is giving that certification there. I suggest you could not argue that it was Anne Brown, the director, who was purporting to provide the certificate required by the prescribed information. If that's right, the the second point is, have the requirements of section 44 been met? To which I say no, you've only got one director's signature. The third question, I say, doesn't arise because there isn't any realistic reading of this part of the certificate which suggests it's an agent, whether an initial agent or a general agent in section 2129. So, for the reasons that we've already discussed at length, we say this certificate is invalid because it hasn't complied with section 44 of the Companies Act.
Well, that's not quite the end of the inquiry, is it? There are two more questions to be asked. If it doesn't comply, is it nevertheless substantially to the same effect?
Yes.
And if it's not substantially to the same effect, applying the approach in Osman and Nat and the Elim case, is that non-compliance fatal?
Yes. So you deal with those points in that order. Effectively, if you haven't complied with section 44, you've got an unsigned certificate. And my submission would be that that is contrary to the requirement of providing a certificate.
Sorry, contrary to?
The essence of certifying something,
Yeah.
or providing a certificate. It's a different kind of case from Elim Court. And the facts in Elim Court were different as well. Because in Elim Court, my Lord Justice Lewison, you'll recall, the relevant notice under the right to manage regulations has the words above the signature signed by authority of the company. And there's then a space for signature. And in Elim Court, the question of whether Mr. Joyner, who was a director of the RTM company, was or was not authorised, was not disputed. The basis for which that acceptance of his authority was taken is not clear from the report. There are a range of possibilities invoking agency and section 74 and everything else, but it's not clear. So one had quite simply a form which allowed for a signature by an authorised member or officer, and a requirement that be signed by authority of the company. And those on the facts, and it's a very narrow factual point, but those were the facts on which the upper tribunal said it was valid, and the Court of Appeal agreed with the upper tribunal's reasoning. So I say, factually, it is different. And the notice in Elim Court was not a certificate. It wasn't a document which purported to verify important information for the purposes of the tenancy deposit scheme. So, for those reasons, I say that Mr. Justice Saini in this case was right in what he said at paragraph 87 in his judgment, that the certificate in this case has a particular legal purpose. Sorry.
No, you just remind myself of what he did say in the paragraph. 87.
Paragraph 87, yes.
Yes.
legislative decision made to impose some formality as to who must sign in this context. And for those reasons, I say that the proper execution is valid, is an important element of validity, such that its omission is one of those cases where it does give rise to an invalidity. The third point is the substantially to the same effect point. And on that, the landlord relies on Miss Brown's signature to the tenancy agreement. That's in page 37 of the supplemental bundle. Yeah. And probably this is, I think, the one signature in the bundles that we've not yet looked at. It's page 37, and it's got the signature of Mr. Brown, dated the 26th of July, which is the date of the tenancy agreement. And echoing the point I made earlier, signed by the above named for and on behalf of Northwood Solihull Ltd. So here one has section 43, Companies Act, being engaged. You've got a contract, and you got the signature by one director for and on behalf of. So that is absolutely fine for the purposes of the tenancy agreement, but it's not good enough in my submission for the certificate, because that requires more. That requires proper execution, and execution that's good enough for a contract is not good enough under the Companies Act for a certificate.
So if, for instance, let's suppose that you enter into a contract of sale of goods of a certain quality, and they are to be certified by a company as conforming or not to the specified quality, you would say that such a certificate would have to be executed by the company, by two of its directors.
Yes, I would. That would be the starting point. Yes. The contract itself wouldn't need to be, but if the contract provided expressly for a certificate, which was in effect a freestanding document, yes, that would need to be executed. May I just confer for a moment? My lords, my learned junior wishes to address you on one particular point.
Yes,
Just
Mr.
that
Cottle.
you have the 1988 regulations with the forms that were handed up during the short adjournment.
Oh, do we? Sorry, I haven't looked at them. Yes.
And at the back of it, there's a different capacity
Yes.
in which you could sign. And just in terms of practical housing, you recall that the Housing Act 1988 liberalised the regime whereby a number of private individuals who were prepared to put their house on the private renting market without the fear of somebody becoming Rent Act protected tenant with all the statutory controls that involved. And so you get to a situation where come 2010 or so, Parliament is talking about the number of letting agents, the number of managing agents, and talking about regulation of letting agents and managing agents and we get to the Deregulation Act, and we see the reference to letting agents. And my submission is that really, when you look at the forms, the capacity in which people were expected to sign was as the landlord. And when you've spoken about as agent, it was an independent third party, letting agent or a managing agent. Maybe it was a son or an uncle doing it on their behalf, but it was somebody other than the landlord. And in answer to my Lord Justice Snowden's point that every time a company signs, they sign as an agent, because of course they can't physically do it themselves, they have to have somebody doing it on their behalf. That is embraced within the wording of section 44.2, which talks of course about somebody doing it on their behalf. And just to employ my learned friend Mr. Heather's application of analysing the certificate in this case, if you look at the certificate, it's quite clear that one signatory is being put forward on behalf of the company. And same too with the Section 8 notice. It's come from the company, on behalf of the company, there's one signatory. And the real critical question from this case is whether the Section 8 notice, looking at it in terms of the Company Act requirements, is a document. And my submission is simply that the document didn't change its meaning between the 1985 Act and the 2006 Act. We still have the definition of document in 744, which included a notice. And quite plainly, notices under Section 8 are documents for the purposes of the company.
Sorry, which section contains a document?
Section 744, it's in the authorities bundle.
Of the Companies Act?
That's right, 1985.
Oh, I see. Sorry, I thought you meant it was a section of the 2006 Act.
Yes, well, that's in relation to the communication provisions.
Yes.
But it's at tab 7.
Right.
And the simple point from this case is that when a company purports to sign a notice, as they did in this case, then Section 44 applies. But there are other mechanisms. My learned friend Mr. Heather has quite clearly explained appointment of attorney or under 744 under the Articles of Association for dealing with that. But if it was on behalf of the company by a signal, a singular signature, just a sole signatory, that wouldn't be enough to comply with Section 44 when it comes from the company, even though they're signing as an agent of the company.
Thank you, Mr. Cottle.
I'm very grateful to my learned junior. My lords, unless there are any questions.
Richard. I've just got one. If you go to the prescribed information order, the point that came up at the end of this morning, as I understand it, your argument in Article 2.1g, little Roman 7, is that the words certificate signed by the landlord bring into play Section 44.
Yes.
Because you say it has to be a method of execution of a certificate by the company. In little double b, there's a similar expression, information provided by the landlord. It's impossible to read little double b other than in terms of agency, isn't it? And the information would necessarily have been provided by agents whose acts in supplying it are attributed to the landlord under principles of agency.
Yes, that is right. The handing over or provision of the information would be done by the hand of an agent.
And what's required to be certified under little double a is that the information so provided is accurate to the best of the knowledge and belief. How can you read that other than in terms of certification to the knowledge and belief of agency, of agents of the company?
Well, because the signature requirement is by the landlord as to the information which has been provided on its behalf by agents, employees, etc. Notwithstanding that it is the practical reality that it is agents who will do that that bit of it. The certification has to be formally done by the landlord in accordance with section 44.
It's quite cumbersome, isn't it? So Miss Miles could give the information to the tenants. You accept that that's done by the agent.
Yes.
And then Mrs. Brown and another director quiz Miss Miles about her knowledge and belief, and then sign the certificate.
Yes. Effectively, yes.
I mean, the funny thing here, of course, and this must be typical, is the information is contained in the document that the agent signs.
Yes, it is.
It isn't that the agent provides information and then the landlord signs. It's the same document.
Yes. It is more work than perhaps some landlords would like, but it is not onerous.
Yeah.
It's a, sign this and do you mind witnessing it? I'm going to sign this, would you mind witnessing it? That situation. And it's common.
Yeah.
It's just not what we're used to. Did that answer my Lord's question?
Thank you very much, Mr. Heather. Mr. Bates, you're entitled, if you wish to reply only on the cross appeal.
And I will take that invitation to make two very, very short points on the cross appeal. Because when I addressed you earlier, I simply said, of course, we've got grounds 2 and 3 in the cross appeal, which are the substantially to the same effect, and then the NAT point. So I'll address those 2 points now very briefly in 5 minutes or so. On substantially to the same effect argument on the certificate, so if there is indeed something wrong with the form of the signature, is it nonetheless substantially to the same effect? I just simply make 2 points. The first is it contains all of the prescribed information. That's why I took you through it at the beginning, with paragraphs 1 to 6 relating to A to F, the order, and paragraph 7 relating to G in the Roman numerals. The extent of the error, if there is one, is not having a second person sign the certificate. If you're asking yourself, is it substantially to the same effect, you ask yourself, does it fulfil the statutory purpose? And my authority for that, just for your notes, is in Pease and Carter, tab 27, internal paragraph 39(4) of the report. If it contains all of the statutory information about how you get the deposit back, who's holding it, how the dispute resolution mechanism works, then it does, in my submission, achieve its statutory purpose. Even if it's not substantially to the same effect, we have the NAT line of cases, moving through ELIM to Cheer Up Mate, and then the Pyramid RTM case from recently. The point I simply make here, or there's 2 points I simply make here. First, it's clear from that line of cases that if there's an error in something which itself is only imposed by secondary legislation, that's a pointer against invalidity. So where Parliament specifies a document or a person must do X and they fail to do it, that is more significant than if a mere SI requires it. And here it's the mere SI. And secondly, of course, to repeat a point I made under the previous ground, everything apart, on this assumption, everything apart from the form of signature so as to comply with Article 2(1)(g) is met. Respectfully, we say nothing would have been improved the tenant's position by having a second signature added. They know all that they need to know about where their deposit is and how to get it back. So Parliament, we respectfully say, would not have intended invalidity in those circumstances. We end where we started. It's a practical regime. The tenant knows all they need to know. By hook or by crook, that is enough. I might have 1 moment. My lords, thank you very much.
Thank you very much, Mr. Bates. Well, thank you both very much for your interesting arguments. Obviously, the points in the case are of quite wide significance to landlords and tenants generally, so we will reserve our judgments. You will get a draft in the usual way, which will be your opportunity to correct our English, but not our reasoning. We would hope that in the light of the draft judgments, you will be able to agree a form of order. If you can't agree a form of order, please make short submissions in writing, and we will make the order that we consider to be appropriate. Thank you very much.